Case 1175, Sharma versus SUNY at Buffalo.
Good morning, and may it please the court. My name is Joshua Lippis, and I represent the petitioner in this matter. Petitioner brought this Article 78 petition to challenge the University of Buffalo's determination finding him responsible for a violation of the university's student code of conduct. This determination was arbitrary, capricious, and unsupported by substantial evidence. In my papers, I detailed numerous violations of petitioner's right to due process, the law, the university's own rules, which led to this decision. I would like to briefly highlight some of those violations. The university denied petitioner the right to be represented by an attorney at his hearing. The university's rules state that every student may have an advisor of their choice, but that
He
no...
was told, by the way, that he could have an advisor, right? He was
Yes.
aware of that.
He's aware that he could have an advisor, but the rules say that no one may represent the student. Both the petitioner and respondent relied on a 1995 Second Department decision in Gruen v. Chase that held that the State Administrative Procedure Act applies only to adjudicatory proceedings required to be made on the record. In this case, both New York education law and the university's rules state that the hearing needs to be made on the record. So therefore, he should have been allowed to be represented by an attorney. Similarly, both New York education law and the university's rules require that petitioner be allowed to make an impact statement at the point in the proceeding when the hearing officers are deciding appropriate sanctions. Respondent points to the end of the hearing when my client was told he can make a statement, but this is not at the point when the hearing officers were making their decision about appropriate statements. Therefore, they again violated New York law and university rules. Similarly, the respondent did not appropriately allow for the submission of evidence. On December 26, 2017, my client received a letter that said that he must submit all evidence by January 2nd. It wasn't until January 29th, 27 days later, that he received the charges and the evidence that was against him. So how is my client supposed to provide evidence when he didn't even know the charge against him or the evidence that he was facing?
So these accumulated violations of the university's own procedures and protocols in running these proceedings violated your client's due process. Is that what happened here?
Correct. Due process, the law, and the university's own rules.
And this is under, this is our standard is arbitrary and capricious for those arguments.
Yes. Yeah, exactly.
Because you have substantial evidence questions.
I do.
Or concerns relative to the hearing and the proof and et cetera.
I do, Your Honor.
Okay.
Why don't you move on to those issues
Substantial
with respect to the substantial evidence issues?
When you look at the decision brought forth by the university, their decision was made on the statements of the complainant and text messages. These text messages is where I really have a problem with their substantial evidence. These text messages were taken out of context.
Couldn't the decision have been made on the testimony alone of the complaining witness after a credibility determination having been made?
I mean, technically, I'm sure it could. We'd have to ask the hearing officers if they felt that would have been sufficient to make a decision based solely on her testimony and not the inclusion of the text
And going
messages.
back to the text messages, isn't that for the fact finder to determine what weight to give to Singh?
I guess, Your Honor, yes. But the text messages themselves were treated with speculation. The fact that he had deleted some text messages 130 days after he stopped talking to the person, they said was a consciousness of guilt, or at least respondents said it was a consciousness of guilt.
Yeah, and our standard here, when we've talked about substantial evidence, but it's such relevant proof as a reasonable mind may accept as adequate to support a conclusion or ultimate fact.
Yes, Judge.
So when we gather everything that took place under here, we've got to apply it to that definition of substantial evidence.
Yeah, this court also said that it's marked by its substance, its solid nature, its ability inspire confidence, but it does not rise from bare surmise, conjecture, speculation, or rumor.
And your argument is, when you take these out of context, they fall more into the speculation and rumor?
Yes, Judge.
Okay. I
Yes,
think
Judge.
we have that argument, Counsel.
Yes, Judge.
And you got a penalty argument, don't you?
Well, as far as the penalty goes,
Is he out of school now?
he is, Judge. He graduated.
Yeah.
Okay.
And just
Sort of like the enduring consequences you're concerned that this is on his record?
Judge, he was found responsible of sexual violence. That tag will follow him around whenever his academic record is in question. If he wants to go to grad school, if he applies for a job and they ask for his academic transcript, there will be a notation saying, you were found responsible for sexual violence. I think that that is a big ramification, regardless of whether he graduated or not already.
Thank you, Counsel.
Thank you, Judge.
May it please the court. I'd like to turn first to the due process and procedural arguments, but preliminarily,
Here's my first question.
yes,
Is this an adjudicatory proceeding as defined under the State Administrative Procedures Act?
no, it's not. And the reason we know it's not is because not only the Gruen case that my friend on the other side cites from 1995, but the other cases that we cite in our brief from the Third Department, the Doe versus Cornell in 2018 and Doe versus Skidmore in 2017,
Yeah,
say
those
it's
are not
not.
substantial evidence cases, though, are they?
Those are not substantial evidence cases, but my point in responding to your colleague's colloquy was that the court in those cases addressed whether this is a matter where the right to counsel attaches based upon SAPA. And the court in those cases held that notwithstanding this new education law, Section 6444, that my friend on the other side relies on, still the right to counsel does not attach.
Yeah, because, and I know that I'm not dealing with apples and oranges. Let me tell you what my thought process is, okay? I understand that those are subdivision 3 cases, okay? That the whole process is unfair and not a hearing case, the cases you just cited to, the Third Department cases. And so I guess the idea is that if SAPA is applicable, then you're entitled to a hearing, and then therefore you're entitled to counsel. But when we deal with this entitlement to a hearing, I guess the argument could be that it's arbitrary and capricious because there was no due process because I could get my hearing. But once we open the door to a hearing, then we're dealing with generally subdivision 4 cases, substantial evidence. So how do you square those two?
I'm trying to be responsive to Your Honor's question.
Yeah, in other words, your position is SAPA is not applicable.
That's right.
Those cases that you say the court determined they're not applicable, is your argument that they're not applicable in general to these types of proceedings? Or is it, in those cases, it really wasn't a hearing case? Their objection wasn't the substantial evidence is the hearing. The objection was that the whole process was unfair.
Well, in those cases, I do believe that the objection was a process-oriented objection.
Right.
Certainly, this court has always analyzed, as far as I'm aware, the evidentiary arguments under the substantial evidence standard, including after the education, both before and after the education law was passed, and procedural arguments based upon issue of law or arbitrary and capricious type standard or the like. And it's always maintained that division of analysis even after the education law. Certainly, the way this case has been litigated and the way this case has been briefed. I hope I'm being responsive to Your Honor's question.
Yeah, I know, I may be confusing you a little bit, but once they open the door to give you a hearing,
Yes.
you have that hearing?
Yes.
That's the problem. It appears that it does meet the criteria under SAPA. That
I
it's,
know
what I'm saying? So then once that opens the door, his arguments in the first instance are not the what took place in the hearing, other than all the trimmings around it. His argument in the first instance is, look, the way this was set up, they just don't meet out due process because, it's an unfair process. Then I think his second argument is okay, even given this unfair process, once we took proof and we had our hearing, we jump into subdivision 4, and therefore, the standard is substantial evidence. And because we were given a hearing, And because it was an adversarial hearing, SAPA must be applicable, and therefore, the fact that I wasn't provided a hearing in his first argument is also in violation because SAPA would require counsel.
I think I see what you're saying now.
I know it's a little bit circular, but I think that's what his point is.
I see. Well, then let me respond to that point. The answer to the question I think you're asking is no. The question under SAPA is not whether a hearing is ultimately provided. Here, of course, one was provided. The question under SAPA is as an initial matter, is a hearing required? And there, those third department cases that I mentioned are squarely on point. As an initial general matter, a hearing is not
And you would say that it's not required under subdivision 4 because it's not pursuant to the direction of law.
That's right. But
I
even
can give you a hearing, but I'm not, there's no statute that requires that I do so.
that's exactly right. But I'd like to put to rest any of this confusion. Let's suppose, let's go as far as assuming that SAPA does attach. Even if SAPA, the General All-Purpose Administrative Procedure Act for the state, does attach, any right to counsel is subsequently displaced by the more specific education law, because the education law, under a specific controls the general type of analysis, the education law specifically addresses who and to what, who may assist a student at a disciplinary hearing, and as far as the level.
We're to read statutes, if we can, so that they can coexist together.
That's right.
Yeah.
That's right, and the education law in this context, which specifically deals with the issue, says a student is entitled to an advisor, which petitioner was given the benefit of here. I understand he didn't show up at the hearing, but that's a different matter. But as far as the level to which the advisor can participate, whether it can be active representation or the like, so even if the advisor is attorney, the education law delegates that decision to the individual institution. The institution here, SUNY Buffalo, has chosen not to allow active representation by the advisor.
Here, excuse me one second. Here's where I'm coming from, I think. The standard of review determines the procedure. It's reverse, I realize that. But if the standard of review is substantial evidence, and apparently you think so because you transferred it up here, or somebody did, right, then it has to be a hearing directed by law, correct? Pursuant to 78034, right?
Yes, Your Honor.
And if it's a hearing directed by law, the SAPA definitely applies, is your point, right?
Well, that's
If
not.
SAPA, but my point is, do you agree that the standard of review affects the procedure?
I agree that in theory the standard of review affects the procedure, which is why I'm trying to offer a solution that even if we get to.
No, but here, if we follow the third department with respect to hearing as appropriate, under enough is enough.
Right.
Therefore, it's not required by law.
Right.
You're now addressing the other thing. What if we go the other way? I get that.
That's right.
But if we follow the third department, hearing as appropriate, we wouldn't go down the SAPA route.
That's right.
Gotcha.
That's right. As the third department did not go down.
Yeah, and
separate.
let me get right to something quickly with you, because I think you may have misspoke. Your position is not that this is by direction of law, the hearing, is it?
Our position is not that the hearing is by direction of law. That's right.
Your position is that you're not required to give a hearing.
That's right.
But you did give a hearing.
That's right.
And therefore, you're not required, this is what Justice Curran's position is. It shouldn't be here. It shouldn't be here if it wasn't under directional law, because the only way we get it, we only review questions of substantial evidence unless we decide for judicial economy we hear the other type cases, the subdivision 3 cases, arbitrary and capricious. And the point is that if it wasn't pursuant to law or under direction of law, under subdivision 4, it shouldn't be here.
I do understand that tension.
Yeah.
Certainly this court has routinely heard these exact types of cases, college discipline cases transferred up from the Supreme Court, both before and after the education law. We're playing on the playing field that has been carved out.
I mean, I think what's been going on, not only with our courts, the other departments, and arguably even the Court of Appeals, is that if it was a hearing, it's reviewed under substantial evidence, and I haven't heard a case argued yet that it shouldn't be sent here if a hearing was had because it wasn't under direction of law.
That's-
And counsel, in fairness to you, you know,
I know
this
this
is,
is not
this is
right.
not the issue that you came here to argue, and you're.
Your Honor, I'm here to answer the court's question.
No, you're doing a wonderful job doing that, but in fairness to you, this is a different issue that, but why don't you wrap up your argument?
Sure, well, I guess I'd like to begin the argument, but I do want to say, I think the issue of failure to preserve deals with most of these procedural arguments. Now, my friend on the other side in his reply brief essentially says that we didn't preserve the argument of failure to preserve, cites a variety of cases on that point. The problem is, in the Article 78 context, unlike the context of those cases, failure to preserve is, as Your Honors were saying in terms of deciding issues of law, is essentially a jurisdictional inquiry in the Article 78 context, and that's what the Court of Appeals in matter of con.
I'm sorry to do this to you, but if it's not an adjudicatory proceeding, why is there a preservation rule?
Why is there a preservation rule?
Why should there be a preservation? If it's not a hearing required by law, if it's not an adjudicatory proceeding, shouldn't we just be looking at the whole record for rational basis and arbitrary and capricious?
Well, Your Honor, I'm happy to address the merits of the numerous procedural arguments that the counsel made.
And I'm getting you back to exactly what the PJ here said we're going to get off. So I just want to let you, in my mind, they're related to. So just give that some thought maybe for the next appeal. Thank you.
Understood, Your Honor.
Yeah, what is your point with the preservation, though? Because I'm having a hard time following you with that. In other words, the preservation that took place in the appeal below, at SUNY?
Preservation has to be made during the administrative process. So there has to be an objection during the administrative hearing. Our position is and, but some courts have said or, an objection made during the administrative appeal. Here
Yeah, so your argument is any arguments that he's making here that he didn't make below at the hearing, or also, and in addition, make at the appeal process below, that they're not properly before us.
That's right.
Okay, I
Yes.
understand.
Yes, that's the argument. I do want to just address two of the procedural arguments he raises on the merits, even putting aside preservation. He points to the issue of failure to have been allowed to make an impact statement at a particular time during the proceeding. That is one of the arguments that we view as not preserved. But even if he is correct that he should have been, that the proceeding essentially should have been a bifurcated, for lack of a better term, responsibility phase and then sanction phase, even as late as his reply brief, and frankly even today, he identifies no prejudice from his being allowed to make the impact statement on the timetable that he actually made it at the end of the hearing, as opposed to after responsibility was adjudicated. Also, there is this issue about the deadline for submission of evidence, and I do agree with counsel on the other side that it's initially troubling that the deadline was set before the charges were filed. However, after the charges were filed, the petitioner did, in fact, submit evidence. That evidence, in fact, was considered at the hearing. And again, in his briefs, he doesn't identify any further evidence he wishes to or tried to submit, but that was not considered on timeliness grounds. I'll wrap up quickly with the issue of substantial evidence. There's ample substantial evidence in this case, basically for the reasons, all the evidence recited at pages 7 to 15 of our brief. All the issues he raises, as I think Justice Troutman, you were addressing in your colloquy with my friend on the other side, those are issues to be taken account of by the fact finder. Credibility issues when there's divergent testimony. What types of inferences can reasonably be drawn from, for example, a selective retention of text messages. It might be possible, although I think the record here is quite strong, that a fact finder could look at this evidence and draw different inferences. That does not vitiate substantial evidence. Substantial evidence is not whether there was an alternative rational outcome. The question is whether the outcome that was reached was reasonable, and it amply was. So we ask this court to confirm.
Thank you, counsel. Thank you.